When the plan reaches maturity. You like those euphemisms? Okay? We've got a bunch of steps that need to be taken in settlement. Now, Rebecca has done a really great job, she and Aaron, in stepping forward and helping make what we're doing with the settlement process even better than it was years ago. We've tried to pay attention to, again, that's that 2020 or 2015 hindsight. If we had done it differently, it would have been better. Not necessarily that it was bad, okay? And she's going to walk through all of this with you.
Okay. Clearly our goal is not to scare the bejesus out of all of you while you're sitting here saying, what did I take on? Because we're here, and this is what we do. What we need to do is have you tell us what exactly went on, and then we'll say, please bring your troubles, your paperwork, the big green binder, drop it here. I will get in touch with you as needed, but we'll try and do as much as we can, as quickly as we can, so that you can go on with your lives and not feel like I am this executor forever. So a good defined process means we'll give you a checklist from the get-go. We'll tell you what you're going to do. We'll tell you what we're going to do. We're going to follow up and nag you as necessary, some more than others. Sometimes you'll roll your eyes when you see it's me on the phone, but that's how we get there. So how particular assets are owned determines the settlement process. How is your stuff going to pass? I was speaking with some of you over the break about it comes back to funding. If you own it in your own name, it will pass under the terms of your will. If you own it in a revocable trust, it'll pass under the terms of that trust. If it's in an irrevocable trust, same thing. What about that IRA account that everybody says, don't change the ownership on your IRA? That's very true. But there are beneficiary designations that will control how that passes. Does it go through your trust? Did somebody forget about that? This is why we send you every year that asset detail report. We want to know how everything is owned. We also will want to know who the beneficiaries are. Did we create a perfect plan that's now not handling any of your assets so that it's not really doing what you wanted it to do? So the particular assets that may need to be probated is that new bank account you opened up after you did all your funding and didn't tell us about, and it's just in your name. Now the probate court is going to have control over how that asset passes, and that will go under the terms of your will. For most of you, that will be coordinated with the rest of your plan, but it means that piece is not going to move as quickly as you would like. And you're not going to get appointed an executor in a day and then be able to write checks.
Keep in mind that little individually owned checking account that has $100 sitting in it that you just never got around to bothering to close is every bit as much as an asset as that $100,000 insurance policy that we got to deal with it. So we got to contact the bank, someone has to deal with it. So keep in mind, simplicity is ideal. And we're not always in a position after the fact to tell somebody, hey, before you died, you really shouldn't have left these 12 account opens.
Yeah, nobody needs that many toasters.
Think about that when you're...
Yeah, don't be like the one client we had who came in, and she and her husband, like most of you, have been very, very frugal their whole lives, in their 80s. He's now having serious health issues, and they had diversified their investments. They were in 10 banks, in 64 different accounts. And then, after we got started working with the new financial advisor, we discovered that there was this mutual fund and that mutual fund, and we found another $1 million they'd kind of forgot about because they weren't getting, on the mutual funds they were getting dividends, but they had other stuff, annuities, whatever, they just lost track of. Organize, consolidate, make sure you're working with a good advisor.
In that tab in your binder that says assets, that's a really good place to put a sample statement from everything you've got. It'll at least help us track down. I don't know how many times we've contacted banks and said, could you tell us about every account so-and-so owns? And they send us 2. And I say, I've got a statement here from account number 3. How come you can't find it? I don't know. That doesn't help. So these are overall the steps that you would go through in settling an estate. The pre-maturation means we've done some planning so that we have something in place that will hopefully eventually get your assets where they're supposed to go. Obtaining authority means who can do something with the assets that were only in your name after you've passed. If they're joint, then you've got at least another individual who can start doing something with them. If they're in your trust, you've got a successor trustee in place to take over so that bills that need to be paid immediately can be taken care of, and life can continue to go on almost like normal. Then control property, we need to know what's out there and start getting access to that. So every account that you have in any way, shape, or form, somebody will need to get in touch and say, so-and-so has passed, this is who now has the right to decide where these funds are going. Take an inventory, we need to know the value of everything that's out there on that specific date of death, and then to certainly keep track of it going forward, whether the assets are increasing, decreasing. We'll need the value to prepare an estate tax return, and then we'll also need to make sure that we've got math to do distributions. So inventory and valuation go together. You may have items in your house that you've never bothered to have appraised for personal purposes, insurance purposes, but now we need to know, what is your artwork worth? What is that jewelry in the safe deposit box worth? So we may have to have appraisers involved. And then taking care of business can mean several things. It means somebody, if you've passed away and you owned real estate, I'm certain in the winter in Connecticut, you might want a little heat on in there so that you're not worried about pipes bursting, any vandalism issues. You're going to want to make sure that insurers are aware that this property is now going through the probate process or whatever. If it's in your trust, you're going to want your successor trustee to be an insured so that this is going to be handled if you have those kinds of problems. If you're in business, that's a whole lot of other stuff we could be talking about. And then we'd have to make sure that our pre-planning was sufficient to make sure that those operations could continue. Elvin?
So you're valuing assets both in the trust and outside?
You are valuing everything you had any sort of ownership interest in. And I'll tell you a little fun story about that when we talk about the estate tax return a little bit. Because we don't have an estate tax for estates under $2 million, but we have a probate court fee that's calculated on your assets. Call it what you will.
You could call it a tax, but they call it a
But it's not a
probate fee.
tax. It's a fee. It feels the same cutting the check. Dealing with creditors and claims. There are very few people that are going to pass away without at least one outstanding utility bill, maybe a last doctor's bill, ambulance bills, credit card statements that are still sitting out there. These are people that we'll need to get in touch with. If there are sufficient assets to pay, we will help you take care of that. If there are not, we will help you take care of that. Doing a final accounting, that's for the assets that pass through probate only. We're going to let the probate court know what came in, what went out, to make sure that those fiduciaries we talked about earlier have done what they're supposed to do. There is a second check on them. And then distributions, where's it supposed to go? We've got to get it out to everybody. So communication, I think we've talked about that a lot. We talk about a lot as far as when you're doing planning with your spouse. You want to talk about what you both want. You want to talk to your successors about what you want for disability. If you have any of those particular items that you are convinced that this particular daughter might want, everybody needs to know. The personal property can be one of the trickiest things to deal with because that's where a lot of the emotional investments are. Talk about them. We will give you a list where you can actually write these things out ahead of time. I want this china collection to go to so-and-so. Tell us. Use those pages. And then it makes it easier when the time comes and everybody's looking at a house full of stuff. What do we want to do with this? A little bit of guidance is always appreciated.
One comment is, among the many goals families have when they come in, often privacy is among them, and that's intra-family privacy, where the parents may want to safeguard the interests of the children, but they don't necessarily want their children to know exactly what's in your checkbook or even where your checkbooks are, which is perfectly reasonable, except the more private you are and the less communicative you've been to those who've been assigned to these duties for which they never interviewed for that job, the harder a lot of this process is going to be. And so I think the key is that dividing line between knowing, family members, I've named you, and make sure you're in communication with these folks, and you should really come to this workshop they do in May that'll give you a preview of what the job's going to be like. But what Rebecca's saying is, you don't have to give them the bank statements. Have the bank statements where they can get them when it's needed. So kind of that dividing line between, I don't necessarily feel comfortable sharing everything right now, but I want them to know that my affairs are in that safe there, and so when the time comes, here's the combination and here's how you do it.
2 points on that too. Yeah, one is, that life insurance policy that there's really no record of because you're just holding it and it's not paying anything out. You'd want somebody to eventually be able to collect that. And also on our document vault, that's great that we do a lot of things online and we have all these different passwords that we have to change every 3 months and they require a letter, a number, a color blue, your favorite high school teacher, whatever. You can also centralize, we're not doing the demo this year.
No.
You can centralize that information on the secure document vault so that your family members are not trying to guess your passwords. Some of them may be able to and may be able to crack your code and find your list of all of where your statements are, but you can store that stuff online on our website so that eventually it will be accessible to everybody as well as being, figuratively and literally in the safe. Read the document. Yes, we will read the document. So you're going to want to know if there are specific distributions that have been memorialized, that the executor trustee will follow those instructions, what the standards are for being able to make any distributions immediately at that point in time. If most of you have your revocable living trust, you know that there are standards in there that'll say you can pay under this trustee can pay under these circumstances to these people, so that you can make sure that the process is going to flow smoothly. And yes, if you're going to take on the job of being a fiduciary for somebody else and they have given you instructions, you should read them, you should understand them, and you should follow them.
That's the way you stay safe. That's the way, have we made anybody nervous so far? Yeah. It's mostly about just following the instructions and
if you don't understand them, call us because we might have a clue.
We strive to try to leave those instructions in the English language. We don't always succeed, but we are certainly happy, a la free phone calls, to step in there and tell you just exactly what this means. So if it's a term of art that we need to use, we're happy to try to explain to you, practically speaking, what do you need to do with this language? What does it mean for you in terms of your responsibilities?
So then obtaining authority, if you have a trust of any kind, we can help you do that. We will prepare the affidavit of successor trustee. We will attach to it the relevant pages that any bank or other financial institution is going to want to look at to say, well, just because you told me so-and-so can deal with this, how do I know they truly can? Well, here's how. It will not include all of the private distributions, any of those specific distributions where that part is not necessary for them to understand, but it will say who acts after my death and what can they not do. Those instructions we will provide for you. And then the original documents your successor trustee should have. Your executor should know where to find your original will. So for probate purposes, we would take care of filing that will for you and the necessary forms to make sure that the person that you wanted to act as executor will, unless for some reason they can't, in which case we look further down the line. We will often, because we work with families and we try and involve all of you as much as possible, to the extent that we can let the probate court know, here's a will, here's who's named, here's everybody else who has an interest in this matter, they have no objections to this. We don't always have to have a hearing to make sure that this happens, and we can try and streamline that process if everybody is in agreement with what's already been established anyway.
One nice thing about trust-held assets as opposed to probate assets is the probate, we can only go as quick as we can go. The probate court is going to go as slow as they want to go. And get between getting the information to file the will, setting this hearing date, getting somebody actually approved, it may take a month and a half regardless of us. The affidavit of successor trustee is something we can generate immediately if need be. So if there is something that has to happen quickly, it's just within our scope of powers to operate a lot quicker when it comes to trust, that's all. That's one of the nice things about dealing with the trust assets as opposed to the probate court.
Ancillary probate. If any of you still own real estate, other than in your revocable, trust, or in your own name, well, even in a revocable trust, you may well have to do what's called an ancillary probate in the other state, because we know we got clients who have second homes and occasionally a third home, and you can end up having 2, 3, 4 probates wherever you have real estate located. If we've got it in a revocable trust, or maybe perhaps preferably an LLC, depending upon the facts, we can avoid that. But if you've got property, or you acquire property, somebody I was talking to earlier was talking about buying a second home, if it's in a different state, we have to make sure it gets in the trust, or we're going to have that ancillary probate.